Shalom, good afternoon. So pleased to be together, to have you here. I know I'm really honored to be addressing the real leadership, lawyers, judges, the creme de la creme of the Portland and Oregon legal community. So I think the only thing I can say is good yontiv. And if, for all the non-Jews, are there any non-Jews in the Portland legal community? Well, I wasn't actually going to make you call yourself out, but I'm really pleased that you're here, that all of us are here. This is a very special and rare treat that we have to be here to get together to hear from Dean Chemerinsky. I'm Rabbi Michael Kahanim, Senior Rabbi here at Congregation Beth Israel. I have the pleasure to introduce our guest and to tell you a little bit about the program that we have coming today. Just to let you know how this is going to work, I'll have the opportunity to introduce our guest. He has some prepared remarks, and then we will have John Perry, who I'll introduce in just a moment, the Associate Dean of Faculty at Lewis and Clark Law School, will be moderating a Q&A. So we'll have some cards going around. If you have questions, we'll ask you to put them down on the cards and hand them to one of our assistants here. And we can pass out cards, I think, anytime. So if you have a question, you could just raise your hand and get a card in advance and start to write them down. And we will we'll have those and a chance to get some of those questions and answers as we go forward. Let me have this moment to introduce our guest. Erwin Chemerinsky is the Dean and Jesse H. Chopper Distinguished Professor of Law at the University of California, Berkeley School of Law. Before that, he was founding dean and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law. Dean Chemerinsky is the author of 15 books, more than 200 law review articles, and countless op-ed pieces, and he's argued many appellate cases, including in the United States Supreme Court. He is one of America's most respected and widely cited legal scholars. He graduated from Northwestern University and Harvard Law School, and almost all of his professional career has been devoted to teaching. Dean Chemerinsky grew up in a working-class Jewish family on Chicago's South Side. Relevant to our topic today, he serves as co-chair of the National Advisory Board of the University of California's National Free Speech Center, which champions free speech and civic engagement on college campuses. And among his many other activities, Dean Chemerinsky helped to found the Progressive Jewish Alliance, a nonprofit organization whose mission is to advocate on issues of peace, equality, diversity, and justice. He is the 2022 president of the Association of American Law Schools, a member of the Committee on Science, Technology, and Law of the National Academy of Sciences, and a fellow of the American Academy of Arts and Sciences. It is a great pleasure to welcome before us, Dean Erwin Chemerinsky.
Rabbi, thank you so much for the incredibly kind introduction. It's truly an honor and a great pleasure to be able to speak with you today. Issues of free speech have existed since the very beginning of the United States. In fact, issues of free speech have been there so long as societies have been around. And yet there are things that are different today compared to they've ever been before. Some of that is because of social media. Social media has dramatically changed expression in a way unseen with regard to revisions since the development of the printing press. It's democratized the ability to reach a mass audience. It used to be in order to reach a large number of people, somebody would be rich enough to own a newspaper or get a broadcast license. Now anyone with a smartphone or access to a modem can reach an unlimited number of people. Social media has made speech widely available and gives us all access to information. in a way that otherwise would have been impossible. But social media also makes it possible to immediately circulate false information to a large audience. It gives the ability to immediately circulate harmful speech to a very large audience. Another thing that's changed with regard to free speech is attitudes concerning it. Certainly see this in college students and in law students. I'll start with an example that illustrates this. In the fall of 2017, a conservative group on the Berkeley campus that called themselves the Patriots were planning a free speech week. And they were inviting Ann Coulter and Milo Yiannopoulos and Ben Shapiro and Charles Murray and others. In anticipation of this, it was very controversial, the chancellor on campus, Carol Christ, convened a faculty panel to discuss the topic of free speech on campus. She was kind enough to ask me to be one of the panelists. It was in a large auditorium. Every seat was taken. There were people standing in every aisle, people sitting on the floor. Thankfully, the fire marshals didn't come. And one of the first speakers was a colleague on the faculty, and he said that the largest problem in our society is white supremacy, and he called on the chancellor to exclude any speakers who he'd regard as white supremacists. There was enthusiastic applause from the audience. During the question-answer session, a student stood up and said, she wants the chancellor to stand up for the students. She wants the chancellor to exclude any speaker who's racist or hateful. She said, I don't care what the First Amendment says. It's the chancellor's responsibility to protect us as students. There was wild applause from the audience. I spoke up then as a member of the panel. I said, let's be clear that if the chancellor were to exclude speakers because of the content of their message, she would get sued and she would lose. She might even be held personally liable, and certainly those who are excluded would be able to successfully recover attorney's fees. I gave an example of Auburn University excluding a white supremacist speaker only to be sued and only to be liable in exactly that way. I said nothing would be gained. The speakers would be able to come. If anything, we'd make them martyrs and win more support for their important position. No one applauded when I said that. And yet that's the reality of free speech law. I was so thrilled when Judge Graber invited me to come and speak here today. She's one of my heroes in the legal system, so of course I immediately said yes, I would be delighted and honored to do so. What she asked me to do was describe some basic principles of free speech, as I understand this is part of a series of programs you'll have on the topic. So let me try to summarize what I regard as the law on free speech, especially free speech on campus, in 4 principles. First, all ideas and views can be expressed. Period. Under the First Amendment, there's no such thing as a false viewpoint. There's no idea that can't be expressed. Now, in talking about free speech, I'm speaking of what the government can do. The First Amendment, like all the rights in the Constitution, apply just to the government. So if it's a public university, it has to comply with the First Amendment. But the First Amendment doesn't apply to private entities. A private university doesn't have to comply. Now, there might be other things that regulate private universities. There might be faculty and student handbooks that are a contract and that they promise protection of speech. Maybe there's state laws regulating private universities, such as exists in California. But when it comes to the First Amendment, it's just about the government, including public universities. And the Supreme Court time and again has made clear that the government can't punish speech on the basis of the viewpoint expressed, even if it's a very offensive position. Let me use an example, tell you of a case from about a decade ago. You might remember reading about it. It got a lot of publicity, even if the name isn't familiar. It's a case called Snyder versus Phelps. And it involves a small church out of Topeka, Kansas, the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and use them as the occasion for expressing a vile, anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church went from Kansas to Maryland for his funeral. Before the funeral, they asked a police officer where they could lawfully stand. The officer pointed to a place about 1,000 feet away from where the funeral was going to be held. Before the funeral, they chanted and sang. During the funeral, they were silent, but they held up signs. That night, Matthew's father, Albert Snyder, was watching the news. He was able to read the signs. He was deeply offended. He sued the members of the West Baptist Church for invasion of privacy and for intentional infliction of emotional distress. The jury found in Albert Snyder's favor. The jury awarded him $10 million. The United States Supreme Court, in an 8-1 decision, ruled in favor of the members of the West Baptist Church. Chief Justice John Roberts wrote for the court. He is quite explicit that the government cannot punish speech or hold speech liable just on the grounds it's offensive, even if it's deeply offensive, because under the First Amendment, all ideas and views can be expressed. The second principle that I identify for you is that free speech is not absolute. At least since the 1940s, the Supreme Court has said that there are categories of speech that are unprotected by the First Amendment. This means the government can punish such speech. There are a few categories that are particularly relevant to our discussion today. One example of unprotected speech is incitement of illegal activity. I'm sure you're familiar with the famous words of the late Justice Oliver Wendell Holmes, who said, "There's no right to falsely shout fire in a crowded theater." But I think it's important here, like for all these categories, to separate the legal test from incitement from the colloquial use of the phrase. The legal test comes from a 1969 Supreme Court case, Brandenburg versus Ohio. And there the Supreme Court said that speech can be punished only if there's both a substantial likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. An example, imagine there's an angry crowd on a campus, and imagine a speaker exhorts that crowd to commit acts of vandalism and arson. And imagine the speaker is prosecuted for incitement. I think on those facts, it would not be speech protected by the First Amendment. By contrast, imagine that there's a very controversial speaker on campus, someone like Milo Yiannopoulos. And imagine that a group comes in response to that speaker and causes acts of violence. If Yiannopoulos didn't encourage the violence, if his speech wasn't directed to causing it, he can't be held liable, even if violence results. A second type of speech that's unprotected by the First Amendment are true threats. That phrase comes from the United States Supreme Court. It comes from a case, United States versus Watts, from the mid-1960s. There's a federal law that makes it a federal crime to threaten the President of the United States. The Supreme Court upheld the law, but the court stressed it's important to draw a distinction between, quote, a true threat and hyperbole. The court said only a true threat is unprotected by the First Amendment. The Supreme Court's never provided us clear guidance as to what's a true threat. There's actually disagreement among the lower courts as to what constitutes a true threat. But again, I can give some examples. Imagine a student is walking across campus and an angry crowd surrounds that student, and the student believes that he or she is about to be beaten. Even if no blows are struck, those students can be punished because it's a true threat. Contrast that with another example. Comes from instances that occurred on some college campuses not that long ago. In one instance, someone put what looked to be a noose over a tree branch. In another instance, somebody put what looked to be a noose on a chair in the library. Even if the offender could be caught, the courts wouldn't regard that as a true threat. It wasn't directed at somebody. It was hateful, it was ugly, but it wasn't a true threat. A third category of unprotected speech relevant to our discussion is harassment. There's no right to use speech to harass someone else. Most obvious example, imagine that an employer says to an employee, "Sleep with me or you're fired." And imagine that the employer gets sued. It would be no defense for the employer to say, "But I was only engaged in speech." Now the question is, when is a hostile environment enough to constitute harassment? There aren't a lot of cases yet in the education context, but there are many in the employment context. And they all say, if speech is directed at someone or is so pervasive as to materially interfere with educational opportunities based on race, sex, religion, sexual orientation, it's not protected by the First Amendment. Some courts have applied that in the education context and said if the speech is directed at somebody or is so pervasive as to materially interfere with educational opportunities, then it's not protected by the First Amendment. There was an ugly incident at another campus where somebody tacked a noose to the door room in a dorm that was occupied by an African American student. I think in that instance, that would constitute harassment. And yet, as I'll talk about in a moment, the presence of hate speech on campus, if it's not directed, is unlikely regarded as harassment. Now, as in all areas of the law, there's line drawing problems. When does it cross the line to be incitement? When does it cross the line to be true threat? When does it cross the line to be harassment? But at least these are categories that we know that are unprotected, and then we can argue about where to draw the line. But you'll notice there's one category of speech that I haven't listed as unprotected, and that's hate speech. And that's because in the United States, the law is clear that hateful speech, racist speech, anti-Semitic speech, homophobic speech is generally protected by the First Amendment. Again, I can mention cases that have established this. There's a Supreme Court case in 1992, RAV versus City of St. Paul. St. Paul, Minnesota adopted an ordinance that prohibited burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Burning a cross, painting a swastika are vile symbols of hate. But the United States Supreme Court unanimously declared that ordinance unconstitutional, making clear that the government can't prohibit speech just because it's hateful. There was another case, Virginia versus Black in 2003. Virginia adopted a law outlawing cross burning. It did so in light of a history, an ugly history in Virginia, of cross burning being used to intimidate. But the Supreme Court said a state generally can't prohibit cross burning. It can prohibit cross burning only if it rises to the level of a true threat. There were two companion matters before the Supreme Court there. One involved a large Klan rally on an isolated farm. The other involved two men who had burned a cross on the lawn of a home recently purchased by an African American family. The Supreme Court said the members of the Klan couldn't be punished because even the cross burning was hateful. No one was there to observe it. It wasn't a true threat. But obviously, the men who burned the cross on the lawn of the home recently purchased by the African American family could be punished because it rose to the level of true threat. In the early 1990s, over 360 colleges and universities across the country adopted hate speech codes. These were all well-intentioned, but every court to consider a hate speech code, without exception, declared it unconstitutional. In European countries, hate speech is outlawed. The United States would be one of the few Western nations that permits such hate speech. Why is it that we tolerate this when the rest of the world won't do so? I think there's several explanations for this. I think one is the difficulty of defining what's hate speech in a manner that's not unduly vague or overbroad. Under the First Amendment, any law that regulates speech must be clear about what's prohibited and what's permitted. It can't regulate more speech than the Constitution allows to be controlled. No one has found a way of defining what's hate speech in a manner that's not unduly vague or overbroad. Here I can give you an example. The University of Michigan was one of the schools that adopted a hate speech code. And it did so after a series of ugly incidents on campus. Michigan copied language that's common in hate speech laws in European countries. It prohibits, quote, speech that stigmatizes or, quote, demeans on the basis of race, sex, religion, or sexual orientation. What does it mean to say that speech stigmatizes or demeans? A lawsuit was brought by some sociobiology graduate students. They said their research was about whether or not there are inherent differences between men and women. They said they were afraid that their research might be found to demean on the basis of sex. The federal district court found it to be unconstitutionally vague. Similarly, almost every court to consider hate speech code found it unconstitutional on vagueness and overbreadth grounds. Several years ago, I taught an undergraduate seminar on the question of speech on college campuses. And when we got to the topic of hate speech, my co-instructor, University of California Irvine Chancellor Howard Gilman and I asked the students to engage in exercise. We asked them to try to write out a definition of hate speech that wouldn't be vague and overbroad, because their inclination was very much that such regulation should be allowed. And I think once they went through that exercise, they saw how daunting, if not impossible, it would be to draft such a law. I think the other reason that hate speech laws in the United States aren't allowed is experience has shown that so often they're used against the very groups that they're meant to protect. When the University of Michigan had its hate speech code, before it was declared unconstitutional, every enforcement action under it, without exception, was brought against a student of color. When England adopted its first hate speech law, the initial prosecution under it was against the Zionist group. The prosecutor said Zionism is a form of racism, and therefore advocacy of Zionism violates the English law. Under the French hate speech law, the most frequently prosecuted individual is the actress Brigitte Bardot. She's an animal rights activist and especially opposes using animals in religious rituals. And she's been repeatedly prosecuted and convicted of that law. But maybe most of all, the reason why in the United States there can't be laws against hate speech is that hate speech expresses an idea, a viewpoint. It's a vile idea, but it's still an idea. Justice Harlan wrote famously that to censor words is to censor ideas. We can't cleanse the English language to please the most squeamish among us. And it's for this reason that in the United States, hate speech is protected by the First Amendment. Well, this brings me to the third principle that I want to talk about, and that's that the government can have time, place, and manner restrictions with regard to speech. Even though there's a right to use government property for speech, it's not unlimited. The government can regulate time, place, and manner. Although there's a right to use government property for speech, there's not a right to have a demonstration down the middle of the freeway at rush hour. I think this is very important for colleges and universities. They can have time, place, manner restrictions to preserve the operation of the campus. For example, they can, and usually do, have restrictions on demonstrations outside buildings while classes are in session. They can have time, place, manner restrictions so as to protect the safety of students, staff, and faculty. In 2017, when Berkeley was facing this Free Speech Week, Chancellor Carol Christ was kind enough to ask my advice. I said, have the most controversial speakers speak in an auditorium, not the outdoor area of campus. If they're in an auditorium, then it's possible to control who gets in. There can be metal detectors if necessary. Whereas if it's out on the middle of the campus, there's nothing the campus is going to be able to do to provide security. And so when Ben Shapiro and Ann Coulter came on campus, The campus said they could speak. They could speak in the largest auditorium, but that's where they had to speak, and they had to speak when the auditorium was available, which would be after classes. They objected, and they sued. I think quite predictably, what occurred was they lost, because this was a time, place, and manner restriction. It served an important purpose on campus, safety, and it left open adequate alternative places for communication. I think the hard question for college campuses is, how much do they have to spend on security in order to allow controversial speakers to be present? At what point can they say the costs of security are so great that they're not going to pay the money and not going to allow the speaker? In that Free Speech Week I mentioned at Berkeley in the fall of 2017, the campus paid $4.5 million for security. That's $4.5 million coming from someplace else, coming from the education of students or scholarships or something else that furthers the campus activities. The chancellor asked me the question, did they have to pay the money to do this or could they exclude the speaker? And I said, the law is unclear here. I think there's really two questions you face. One is, what's your stomach for getting sued? Because if you exclude the speakers, there will be a lawsuit against you, and it's uncertain what will happen. And the other is, what do you want the message to be about the Berkeley campus? I think she wisely chose to pay the money and allow the speakers. But what if it wasn't Free Speech Week and the cost was $4.5 million? What if it was Free Speech Month and the cost was $20 million? Or Free Speech Semester and the cost was $100 million? There has to be a place where a campus can say, we can't afford the safety and security, so we're going to exclude the speaker. But it's impossible at this point in time to identify where that line would be drawn. Well, this then brings me to the fourth and final part of my remarks, where I want to talk about some of the cutting-edge issues, especially related to campuses and free speech. I want to talk about a few issues here that are coming up. One is called deplatforming. And if you spend time on college campuses, you're likely to hear this word. And often deplatforming takes the form of students, through their speech, preventing another speaker from being heard. You might have heard of an incident at Hastings Law School in San Francisco earlier this year where Ilya Shapiro came to speak. He had said something very offensive when President Biden nominated Justice Ketanji Brown Jackson to the Supreme Court. And a group of students came and shouted so that Shapiro could not speak, and ultimately the event had to be canceled. There was another event at Yale Law School where speakers were harassed and hassled to make it difficult for them to be heard. And the students say, we have the right to do this because we're just exercising our free speech. I think that's nonsense under the First Amendment. I don't think that there is any First Amendment right to use speech to keep others from being heard. Sometimes in the literature of the First Amendment, this is called the heckler's veto. I don't believe the First Amendment accords hecklers the right to veto a speaker. If it did, then the only speech we'd ever hear is that which no one cares enough to shout down. And that can't be right. I send a message to the Berkeley law community at the beginning of each year, restating our principles with regard to freedom of speech. I emphasize how important it is that we be a place where all ideas and views can be heard. I also emphasize that there's no right to use speech to disrupt others, that indeed, if anyone engages in such behavior, they will be subject to student discipline. We had an incident at the law school not long before COVID where a justice on the Israeli Supreme Court was coming to speak. And our Law Students for Justice in Palestine made clear they were going to deplatform the speaker and keep the speaker from being heard. I sent a reminder message to the school, not mentioning this particular coming event, but reminding them that if students shout down a speaker, those students are violating the student code of conduct, and I will bring disciplinary charges. Thankfully, the students decided to change their plans, They handed a leaflet to everyone who walked into the room. They put a leaflet at every seat. They held a silent protest in another part of the law school, all of which was completely appropriate. Because I believe that the best remedy for the speech we don't like is more speech. As I say to the students, if there's a speaker who's coming who you object to, you can certainly protest in a way that's not disruptive. But bring your own speaker. And the school will help facilitate that if necessary. A second issue, set of issues that's coming up on college campuses concerns social media. I alluded to the importance of social media in my introduction. I understand you're going to have a whole session just about social media. But the reality is that social media has dramatically changed how speech occurs. It used to be possible to draw a distinction between speech on campus and speech off campus. Or in younger grades, the difference between speech in the school and speech out of the school. Social media makes that impossible. Let me, as an example here, talk about a Supreme Court case from just a year ago. It's a case called Mahoney Area School District versus BL. Brandy Levy was a rising sophomore at a high school in Pennsylvania. She tried out for the varsity cheerleading team. She was upset when she learned she was again assigned to the junior varsity. She was furious when she found out that a freshman had made the varsity ahead of her. She went on a social media platform and posted a video. In it, she raised both of her middle fingers, and she repeatedly used the profanity that starts with the letter F. She then went and posted another video, but without profanities. She did this on a Saturday. She wasn't at school when she did this. On Monday, the cheer coach saw this and said it was conduct unbecoming a cheerleader, and said she's no longer welcome to be participating on the cheer squad that year. She could try it again for the next year. There were no other sanctions imposed on her. She wasn't suspended or expelled. But she and her parents sued. They won in the federal district court. They won in the United States Court of Appeals for the Third Circuit. And they won 8-1 in the United States Supreme Court. The Supreme Court made it clear that even though this was speech that had an effect on the school, even though it would be an impact on the cheerleading team, it couldn't be punished. It was speech protected by the First Amendment. I think the greatest threat of social media with regard to speech is false speech. Social media, the internet, make it so easy for false information to be quickly circulated and to gain belief despite its untruth. And we don't have a way of dealing with that under the First Amendment, at least to this point. Generally, false speech, according to the Supreme Court, is protected by the First Amendment. In New York Times versus Sullivan in 1964, the Supreme Court said, there must be protection of false speech in order for free speech to have the breathing space it needs in order to thrive. There was a case a decade ago, United States versus Alvarez. It involved a federal law, the Stolen Valor Act, that made it a federal crime for a person to falsely claim to have received a military honor or decoration. An individual who was on a local commission bragged about having received the Medal of Honor. It was totally false. The United States government prosecuted him on the Stolen Valor Act. The United States Supreme Court declared the Stolen Valor Act unconstitutional. Justice Anthony Kennedy wrote for the court, and he stressed that false speech is generally protected by the First Amendment. That's not an absolute. Obviously, there are instances where false speech can be held liable. Defamation is an example of that. False speech that's injurious to reputation, that's been publicly circulated, can be held liable. False advertising can be punished. Perjury in court can be punished. But the Supreme Court has said generally false speech is protected. And so the question is, how do we protect our society from the dangers of false speech while still respecting the First Amendment principles that have been in place for 200 years? I don't think we have an answer to that question. False speech undermines the whole idea of a marketplace of ideas. Why believe that we benefit from having false speech out there? Now, the hope of the marketplace of ideas is that true speech will respond and that will convince people. But what about all those who are harmed in the meantime by false speech? And why should we believe necessarily that truth will triumph over falsity? If you ask me what I think are going to be some of the most important and challenging issues with regard to free speech in the decades to come, it's going to be very much about how do we deal with false speech over social media and the internet. Finally, in terms of the current challenges, it's the importance of colleges and universities also creating an inclusive learning environment for all students. I think one of the things that we've come to realize is often omitted from discussion of free speech in past years was also an obligation to make sure that colleges and universities are places where all students feel welcome, where all students can effectively learn. And there's an obligation of colleges and universities to do this. I was involved in a case in the United States Court of Appeals for the Fourth Circuit in Richmond that illustrates this. It arose from Mary Washington University. Mary Washington University is a public school. There was a debate on campus as to whether to allow fraternities and sororities in Greek life. 3 women wrote an op-ed in the campus newspaper opposing allowing Greek life. They said when fraternities exist on campus, there's more sexual violence against women. They then got targeted. There were hundreds of ugly, vile messages about them over the then social media platform Yik Yak. Some threatened them with rape and murder. They went to campus officials and asked for help. The campus said there's nothing we can do because it's anonymous speech over social media. In fact, the campus then posted on its website that there's nothing it could do about anonymous speech over social media. They went back to campus officials, and the campus officials said, we'll create a sharing circle for you so you can share your feelings about this. The Feminist Majority Foundation brought a lawsuit on behalf of these students. The federal district court dismissed, saying this was speech protected by the First Amendment. I agreed to represent these students before the Fourth Circuit and argued their case and won. The Fourth Circuit stressed that there is an obligation of campuses to protect students. Under Title IX, they can't be deliberately indifferent to harassment on the basis of sex. Under Title VI, they can't be indifferent to harassment on the basis of race. And so the Fourth Circuit said here that the campus doing nothing in the face of what really were true threats was a basis for liability. The case then settled at that stage. When I send my message to the students at Berkeley Law, I always in the last paragraph remind them that just because there's a right to say something doesn't mean that it should be said, and that I encourage them to also think before they speak about the effect of their speech on others. Well, I couldn't imagine, when Judge Graber kindly invited me to speak here, that on this weekend I would be in the middle of a national and international controversy concerning free speech. Some of you have already asked me about it, and what's interesting here is it fits with much of what I've talked about, including how easy it is for false speech to be circulated on the internet and for people to believe it. So if you haven't heard about it, I'll tell you a bit about it. If you have heard about it, let me tell you what actually happened. Monday, August 22nd was our first day of the semester. On that day, a law student group, the Law Students for Justice in Palestine, asked all of the other student groups in the law school to adopt a bylaw. The bylaw strongly condemned Israel. It asked the groups to promise that they would not invite speakers who supported Zionism or Israel's apartheid policies, that's a direct quote, that they would support the boycott, divest, and sanction movement, and they would have their members go through training about the plight of the Palestinians. Immediately, students reached out to me. I met with the leaders of our Jewish Law Student Association. I met with the Hillel Rabbi. I met with many of the Jewish students. And then I sent a message to the leaders of all of the student groups saying that I found the message sent by the Students for Justice in Palestine deeply distressing. To say we're going to exclude any speaker on account of view is inconsistent with our commitment. I said that indeed under their policy, I couldn't be invited to speak because I support the existence of Israel, though I criticize some of its policies. I said, as our chancellor pointed out, the BDS movement is a threat to academic freedom, and that I would urge student leaders, when they decide what to do, to take into account the importance of it being a community where all feel welcome, where all belong. 9 student groups in those first few days adopted the bylaw. This is about 110 student groups. I was pleased that after my message went out, no additional student groups adopted it. Some said they would reconsider having adopted it. The faculty advisor for one of the student groups resigned after they adopted it. And then the issue faded in the law school. It got some media attention at the end of that week. There was some in the Jewish press. I wrote an op-ed in the Jewish News of Northern California, sending it out. Fox News picked it up. Ted Cruz tweeted about it. Some of the stories were accurate. Most were inaccurate. Virtually no reporter called me before writing the story to know what was actually going on. But thankfully then it just went away in the law school. I didn't hear anything about it for weeks. No additional student groups adopted it. No student group tried to enforce it or excluded any speaker on the basis of views or any other basis. On Wednesday night of this week, I got a message from someone in the communications department on campus saying, "What's happening with this?" And I said, thankfully it's faded away. I guess 90% of our faculty and students haven't even heard about this controversy. On Thursday, 3 days ago, an article appeared in the Jewish Journal titled, "Berkeley Creates a Jewish-Free Zone." It presented a very distorted impression of what happened. If you would read it, you would think that all of the student groups have adopted this, that Jews aren't welcome at Berkeley Law School, or at least in these particular student groups. It was completely fabricated in terms of much that appeared in the story. I immediately wrote a letter, the editor, to the Jewish Journal, setting the record straight. Most important to say, there's no Jewish-free zone at Berkeley Law. Jewish, much of our faculty is Jewish, many of our students are Jewish. We have a wonderful institute, the Helen Diller Institute on Israel and Jewish Studies, the largest Jewish Studies institute west of the Mississippi in any law school. They, just a week before, had a member of the Israeli Knesset come and speak about a book called The Israel Century. And yet none of this got reflected in the article in the Jewish Journal. The fact that many of you have already heard about this reflects that this is a story that went viral. It got enormous coverage in both the Jewish press and in the national and international press. Barbara Streisand tweeted about it on Friday. I've gotten hundreds and hundreds of messages, dozens just today since I arrived in Portland, and they're all based on assuming that what was in this story was accurate, and many of them are quite vile. There's a post on Reddit that says Chemerinsky's not really Jewish, even though his name sounds like it. I am Jewish, really. And I've gotten dozens of emails from alums saying, I'm never going to give money because Berkeley's anti-Semitic. And it really shows me how quickly a false narrative can spread through the internet. I believe that the author of this article had a story he wants to tell about college campuses and about the Berkeley campus in particular, and he was going to use this to fit that. He hasn't been to the Berkeley campus, he hasn't been in the law school, he didn't interview me or anybody else, but he was going to tell the story. I'm certainly glad to answer questions about this, but to me it does show some of what I'm talking about the difficulty with regard to the internet and false narratives, and also about how do we create an inclusive community for everyone, where everyone will feel welcome, where students have the ability to speak and students have the ability to listen and the like. So those are the basic principles of free speech, and I hope that helps as you begin this series. I've always believed that the basis of free speech is that my speech will be protected only if I safeguard the speech that I don't like today. We don't need free speech to protect the speech we like. We need free speech to protect the speech we don't like. We'd always let the speech we like happen anyway. Ultimately, protection of free speech is based on faith. The faith that we are better off as a society allowing all ideas to be expressed, then we would be giving the government the ability to censor particular ideas and viewpoints. I have that faith, at least most of the time. Thank you, and I'm glad to take your questions.
Thank you so much. So much to think about, and it's a complicated subject, but I appreciate how you brought so much clarity to it, and I really honored that. I think it's been rare that our BEMA has had a speaker who's been tweeted about by both Ted Cruz and Barbara Streisand. That's an accomplishment.
Ted Cruz praised me in his tweet, which may be the first time that is I'm sure that is the first time that's ever happened.
I'm sorry. I'm sure your reputation will recover from that particular blow. And just so that you know, Congregation Beth Israel, our temple, has had the honor to be protested by the Westboro Baptist Church right on our street a few years ago. So we have some direct familiarity with the situation that you described. So much for us to chew on. I want to invite John Perry, who is Associate Dean of Faculty at Lewis and Clark Law School, where he teaches constitutional law. His areas of scholarship include civil rights law and international law. And previously, Professor Perry taught at the University of Pittsburgh School of Law and was Bigelow Fellow at the University of Chicago Law School. He also practiced for several years with a private firm in Washington, D.C., and after clerking on the U.S. Court of Appeals for the Ninth Circuit, Professor Perry received his A.B. summa cum laude from Princeton University and his J.D. magna cum laude from Harvard Law School. Welcome you, Dean Perry. And again, if there are questions, continue to put them on the cards, give them to our runners, and they will bring them up to us.
Well, I just want to say thanks for having me here, and so thank you for coming. This is so I made so many notes, but luckily I have so many cards to read from, so you won't have to have my questions. I'm delighted by that. Yeah, just keep them coming. I'm a reader, so my job is to take your questions and sort of sort through them and ask them. But if they're repetitive, I'm sure you didn't all coordinate in advance your questions. So if there's repetitive questions, I'll try to move through those more quickly. But the one on top is right there in the middle of your talk, I think. How has the internet changed our cultural understanding of free speech? And how should it change legal doctrines, if at all?
I think it's dramatically changed our cultural understanding of speech. I think it's unclear how it will change legal doctrine. With regard to the cultural understanding of speech, it really does mean that there's the ability to reach a mass audience like never before. It really does mean that we have access to information like never before. I mean, how many of us have had disputes at the dinner table that otherwise would have just been I said, you said, and you look it up on the phone and you get the facts that resolve it. We have access to all the libraries of the world, all the museums in the world, just at our fingertips. And those are the good things. But it's also brought so much hateful expression, so much vile expression. I've thought a lot about why is it that current students overall are less committed to free speech principles than, say, my generation of college students. And my generation of college students could look at the civil rights protests and the Vietnam War protests as the model for speech. Now the students look at the vitriol on some of the social media platforms, and I can understand why they have less commitment to speech. So I think in terms of the culture, we're in the midst of an enormous change in attitudes with regard to speech because of the internet and social media. In terms of legal regulation, it's not clear. We'll probably get this spring one of the most important Supreme Court cases about social media regulation. You might know that Florida and Texas both passed laws that prohibit social media companies from moderating content. And the Federal Court of Appeals for the 11th Circuit for the Florida law declared it to violate the First Amendment, saying social media companies are private entities. They can make whatever choices they want to be up there or not to be up there. And the United States Court of Appeals for the Fifth Circuit upheld the Texas law. And so given the split between those two courts, I think the Supreme Court's going to have to decide. And that case can be very important in terms of how, if at all, can the government regulate social media. But I think we're early in the history of the First Amendment and social media. There's only a handful of cases from the Supreme Court about it yet.
So the most important question I got was to speak into the microphone. But a follow-up. I'm trying to blend these together.
Yes.
I'm really glad you talked about the cases from the Fifth and 11th Circuit.
Sure.
I found the Fifth Circuit case to be really interesting with the idea of a common carrier and all of that. Can you say a little bit more about the ability of a social media company to regulate what it's doing as opposed to the government's ability to regulate?
I said at the beginning something very basic in constitutional law, and every lawyer in the room is familiar with it. The Constitution applies to the government. Private conduct does not have to comply with the Constitution. My favorite illustration of that is a true story of a conversation I had with my oldest two children when they were 9 and 6. So this was 30 years ago, and we were in a grocery store together. And at the time, Diet Coke had 3 baseball cards pictured on the outside of the package. And my 2 sons were arguing, as they often did at that age, about who was going to get the extra baseball card. And finally I said, be quiet. I don't want to know anything else about baseball cards. Leave the grocery store. My then 9-year-old turned to me and said, you can't tell me to be quiet. I've got freedom of speech. I was ready for him. I said, freedom of speech means the government can't tell you to be quiet. I'm not the government, so I can. To which he, without missing a beat, turned to me and said, well, you're like the government to me, so you shouldn't be able to tell me to be quiet. True story. It's when I first knew someday he was going to go to law school, and he's a federal prosecutor in Los Angeles now. The social media companies, Facebook, Google, YouTube, Twitter, are all private. They get to make the choice about what to carry, just like the New York Times, the Los Angeles Times, or CNN, or Fox News get to make that choice. And that's what the United States Court of Appeals for the 11th Circuit held. Also, we want social media companies to engage in content moderation on their own. If you look at the statistics, Facebook and Twitter engage in tremendous amounts of content moderation, taking down child sexploitation material, taking down hate speech. I'm not sure that a government regulation required this would meet First Amendment scrutiny, but they can do so because they're a private company. I thought Judge Kevin Newsom's opinion from the 11th Circuit was very persuasive, and I'm hopeful that the Supreme Court will agree. I'll even go out on a limb and I'll make a prediction. I think the Supreme Court is going to strike down the Florida and the Texas law. I think it's going to be a 6-3 decision, and Justice Thomas Alito and Gorsuch are going to dissent. Lest you think I have a crystal ball or I'm making that up, when the Fifth Circuit initially said that the Texas law could go into effect, media companies went to the Supreme Court for emergency relief, and they got it from the Supreme Court with Justice Thomas Alito and Gorsuch dissenting. And I think that's our tip as to what's going to happen. I think that we need to put pressure on social media companies to do a better job of content moderation. And I have ideas about how to do that, but I don't think prohibiting content moderation would comply with the First Amendment or be a good thing either.
So many of the questions, I think, reflect, maybe not so much on their surface, but it reflects a frustration sometimes with the way legal doctrine regulates speech. And so, following on from that, do we have to rely on Facebook and YouTube to protect us against false statements that go viral? Or is there a role for the government to step in and correct the market failure, if I could introduce that term in there, to the free, the marketplace of ideas?
I'm very scared of giving the government the power to decide what's true and what's false, except in narrow areas. I believe very much that Joe Biden won the 2020 presidential election. There is no evidence whatsoever, I think, that the election was stolen from Donald Trump. But 70% of registered Republicans say they believe that the election was stolen. I don't want the government to be able to have the power to say they can't express their viewpoint. I don't think it would make the viewpoint go away. And from my perspective, if the government had the power and say it was the Trump administration, why couldn't they take my views and say my views are false and outlaw them? I'm very afraid about giving the government the power to decide what's true and what's false and to censor and to punish what's false. As I said at the end of my remarks, I still have more faith in the idea of let all ideas be expressed and have it play out than to give the government the power to say, no, that's a bad idea. We're going to eliminate that idea.
Well, since you mentioned Donald Trump, he showed up only in the cards. I mean, not in any other way. So let's switch gears with that particular speaker. Does Trump calling on his followers to march on the Capitol, does that constitute incitement or a threat, or is it protected speech?
I think it is a hard and a close question. My own conclusion is that if you look at the words that Trump spoke on January 6th, the words that preceded them, and the context in which they're spoken, it meets the standard for incitement. There has to be a substantial likelihood of imminent illegal activity. I think that existed on January 6th. And the speech has to be directed at causing imminent illegal activity. If you look at his tweets encouraging people to come, if you read what he said in that speech on January 6th, and of course if you look at the context, I think the speech was directed at causing that. Now, whether the Attorney General should prosecute Donald Trump for incitement is a separate question from the First Amendment. I thought this and came to this conclusion before the January 6th hearings, but after watching what unfolded in the January 6th hearings, I'm even more convinced that the legal test for incitement would be met, that what Trump did wouldn't be speech protected by the First Amendment.
So a couple of questions that I think they don't quite relate to Trump precisely, but there's still a kind of a mix of political violence and social media. And these two I'm going to try to blend together. So the most pointed, specific question is, can you comment on the Sandy Hook lawsuits against Alex Jones? And then more generally, the way in which public speakers, use, confrontational lies in their presentations, and then, which leads to all kinds of harm, whether it's emotional distress or economic loss or other things like that. I know that's a broad question, but I think there's something there.
Generally, false speech is protected by the First Amendment, but not absolutely so. As I mentioned, defamatory speech is not protected by the First Amendment. When it comes to a public figure who's suing, they'd have to meet a high standard. They'd have to show that the speech about them was false. They'd have to prove with clear and convincing evidence the falsity. They'd have to prove what in law is called actual malice, that the speaker knew that the speech was false or acted with reckless disregard of the truth. The United States Supreme Court has said if there's going to be liability for intentional infliction of emotional distress, it has to meet the standards of defamation. I think if you look what Alex Jones did with regard to Sandy Hook, it clearly meets the standards for being unprotected speech, even though true speech, false speech is generally protected, not absolutely so. And his, I think, rightly has been found to cross the line. If you look at the things that he said, they were so blatantly false, they were injurious to reputation, and they did inflict tremendous emotional distress.
So just as a follow-on, when people like Alex Jones do what he did, the resulting injuries are sometimes compensable, so long as they can fit within one of the exceptions to the First Amendment. Is that an accurate doctrinal statement?
Yes. What Alex Jones did was not speech protected by the First Amendment. It was tortious, and there are damages. Very large damages have been awarded against him. And I think it will stand up on appeal within the context of the First Amendment. Are there times when injuries are done by speech where there's not compensation? Yes. And of course, there's a lot of injuries we suffer in our society where there's no compensation.
Okay, so this one this is my follow-up, but I'm speaking to the litigators in the room.
Sure.
So Alex Jones has been hit so far, what was it, $40 million in damages in the first case, and it's going to be, I mean, perhaps another equal number. At what point, I mean, the Supreme Court has talked about limits on punitive damages in other contexts and compensatory damages and all of that. I mean, does the First Amendment have a role to play in protecting Alex Jones from having to pay too much damages?
Well, there are limits from the First Amendment in terms of punitive damages. Punitive damages generally can't be awarded for defamation or intentional infliction of emotional distress unless actual malice is proven. It has to be proven that the speech was false with knowing disregard of truth or falsity of the speech. It has to be proven that the speech is false. So there you have a protection. Actual malice is a very difficult standard to meet. There's also a protection, as you say, coming from the Constitution and due process. The Supreme Court has said that grossly excessive punitive damages violate due process, and the court has articulated a three-part test. Judges and lawyers love three-part tests for when punitive damages go too far.
Every now and then we have 4- and 5-part tests too. Three different questions about campuses, and so I mean, might as well come to our shared, experience here. Can you speak to, this is maybe less about college campuses, the first one, but you did refer to this, the explosion of challenged and banned books in schools and libraries, and how do we combat these efforts to remove books and the role of a library versus a classroom space versus other ways in which information is provided consistent with the First Amendment?
I think one of the most deeply distressing things in the last couple of years is in the rise of banning books, but also laws that have been adopted that prohibit teaching particular topics like critical race theory and the like, or the Florida Don't Say Gay law. Those are so inconsistent with what the First Amendment is about. They're blatantly at odds with the idea that all ideas and views can be expressed. Banning books has a terrible history in this country and an awful history throughout the world. I think it's so important that we rise up and express outrage, individually and collectively. I think that the laws that prohibit teaching of critical race theory, if you read them, are incredibly unconstitutionally vague. They do things like, say, prohibit teaching that one race is superior to another, or prohibit teaching about white privilege. Not clear what it means. I was on a panel not that long ago with a teacher in Tennessee who got fired because they thought that he was crossing the line in terms of teaching too much about race and from a particular perspective. How can you teach about slavery without making a value judgment about it? And yet that's what these laws would seem to require. So I think in answer to your specific question, though it wasn't what I was speaking about, I hope it's something that will be focused on in your series, and I hope we'll all find ways to express outrage when it comes to banning books.
So I'm just bad with microphones. I just shout in the classroom and hope everyone can hear me. So recently, the Chronicle of Higher Education ran a story about the University of Idaho, I believe it was, adopting a new set of rules on how its staff, faculty, healthcare professionals, et cetera, could speak about abortion. And there's concern on the Idaho statute they're working under makes it illegal to promote abortion. I think promote is the word that's in the statute. Obviously, statutory language matters critically. And the school, I think, coming out of a general counsel's office, as I'm sure you can imagine, a general counsel is going to be rather conservative in their recommendations because they don't wish to be sued. Basically said something along the lines of just don't ever talk about abortion. I'm sure I've overstated that. But as a follow-on, I don't know if you'd heard of that.
I did. I read the article.
Okay, good. So you know more than I do, probably.
I think that the advice of the General Counsel clearly violates the First Amendment. I think Idaho has prohibited abortion, so Idaho can prohibit incitement in the same way that the government can prohibit incitement with regard to any other crime. So if the speech rises to the level of incitement, then I think it's not protected by the First Amendment. But the government can't prohibit discussion of abortion if it doesn't rise to the level of, say, incitement or true threats or harassment. So I think to prohibit teachers from teaching the topic of abortion, or medical schools from teaching how abortions are performed, or classes from discussing the impact of prohibiting abortion on women's lives and on society, I think that would violate the First Amendment. So I think it again goes to, it's got to fit into a narrow category of unprotected speech, and I think the advice of the General Counsel, if it's, would be struck down in court.
So generalizing from these examples, and maybe let's go into a slightly different direction. There was also a discussion in the New York Times. It was a weird headline. Not all college students are left-wing activists. Which I'm not sure whoever thought they all were. But in there was an incident in which one student talked about how a professor, while they were reading a poem, suddenly started talking about the poem in a particular way that they felt was expressing too much of a view of what the students should share. And so that kind of, for me, was kind of an example of leading into the question of, how do we protect free speech by professors, but also assuring the truth of the information on college campuses, and I would add the tailoring, that you're teaching what you're supposed to teach. And who polices that? Students?
I think that professors are and should be protected by the First Amendment. That's not unlimited. And I think they are and should be protected by academic freedom, and that's not unlimited. There was a Supreme Court case in 2006, Garcetti versus Sabalas, that said there's no protection for the speech of government employees on the job and the scope of their duties. But at least here, the United States Court of Appeals for the Ninth Circuit has said that doesn't apply to academic speech. Judge William Fletcher wrote that opinion for the Ninth Circuit, and I think that's absolutely right, and I hope the Supreme Court will ultimately come to that conclusion. And of course, academic freedom is enormously important for professors in the classroom and outside classroom speech. We saw the consequences in this country in the early 1950s when there wasn't respect for academic freedom, where professors would get fired just for being suspected of being communist or too left. And it strengthened the Association of American Universities, AUP, in their protection of free speech, which is very important. But it's not unlimited. Imagine that at my law school or yours, someone is assigned to teach contract law. And instead of doing that, say, no, I'm just going to go in and talk about college football every day. Well, I don't think academic freedom protects the ability to do that. On the other hand, imagine that a speaker on the weekend goes to a rally that a lot of the students find offensive. I don't think that that professor can be stopped from teaching in the classroom, even when students come forward and say, I can't learn from that. We had an example at Berkeley, and I'll tell the story without mentioning names. Just a year ago, we had a professor who about 10 years ago co-authored a book that was critical of critical race theory. And a number of black students in his required first year course came and said, because he's critical of critical race theory, he's anti-black, and we can't learn from him. You have to assign us to a different teacher, or we shouldn't have to go to his class because it's triggering for us. And I said, I understand, but he's your teacher. We're not going to change what section you're in, and you have to go to class. And I said, otherwise, anytime students say that they find a professor's outside writings offensive, this professor's too liberal, this professor's conservative, they would then say, no, I can't go to class. I wouldn't say that my choice was non-controversial. Some in the Student Affairs Office disagreed with me, but I felt very strongly in that context that that was the right answer. So academic freedom, the First Amendment, protect what professors do. It's not absolute, and I worry about in states that are adopting these laws against critical race theory, how professors could be targeted. And no one can be completely neutral in the way they teach, nor should they be. When I teach about, say, Dred Scott versus Sanford, that struck down the Missouri Compromise and said that slaves are property, not persons, or Korematsu versus the United States, that upheld the Japanese internment or evacuation during World War II, I'm not going to be neutral about that, as much as I try in other places to be neutral and make sure my classroom is a place where all views and ideas can be expressed.
It strikes me too that some professors pedagogically feel there can be value in actually explaining to their students, hey, here's where I'm coming from, this is what I think, but please feel free, debate me, disagree with me.
And I think that professors should have that choice. I generally make the choice in my classes to want both sides to come out when there are both sides to be there. And if there's not one side to articulate it, I will articulate that side. But there's some places, like the cases I mentioned, where I'm not going to try to present the other side. I'm not going to defend slavery. I'm not going to defend Japanese internment. But there's a variety of different teaching styles in terms of how much to express your own views and how much to not express your views within the class. One of the concerns I have that I didn't touch on, because it's not about government regulation, is the way in which social pressure from other students causes silencing of students. And I think social media has contributed enormously to this. And again, I have anecdotes to illustrate it, where if it's a school that's predominantly liberal, conservative students might be reluctant to speak in class for fear they're going to be targeted by their liberal classmates over the social media platforms, or in a school that's predominantly conservative, liberal students being reluctant to speak out. And I'm not sure what to do about that, because it's not something the school is doing. At orientation this year, I talked a good deal about why it's valuable to them to have all views come out in class, because they should understand the opposing arguments. They should be prepared for them. It will sharpen their own thinking, but I see that as a real problem.
In some sense, you're talking about the tensions. I mean, I don't want to make it all about higher education, but I'm sure we could go on about that. But the tensions that exist between, as you were talking about, having a safe and inclusive learning environment, but also protection, for free speech. And of course, those things come together. And you've talked a bit about the link between that and harassment issues and the example you gave from your school. I mean, it would have been very different, of course, if that professor had come into the classroom and used the classroom as a pulpit, right, for expressing some of those views. That would have created a very different question. I don't know how it would have played out, but it would have been a different question.
Yes.
And we have a different one yet again from someone in the audience asking whether there's also a tension with the issue of hate speech on the one hand and striking down hate speech codes, as you talked about, and then contract law.
Say the word.
Contract law, and in particular things like morality clauses that might be included in public institution contracts as well as in the contracts of private institutions and industry. And so what happens there? I mean, can a government have morality clauses?
If it is a public university or a public employer, and the morality clause is used for speech that's protected by the First Amendment, I think the speech interest will win. If the morality clause is used as to conduct that's protected by the Constitution, it used to be those clauses we used against people who are gay and lesbian. I think to enforce those contracts today and fire somebody for gay and lesbian would clearly violate the Constitution. It's a public university. I think if it's used against a professor or a high school teacher for going to a rally over the weekend, however offensive the rally might be, I think that would violate the First Amendment.
When we talk about hate speech, and I think you were alluding to this as I was scribbling notes, and someone else was thinking the same thing. Defining hate speech, right? How much of that definition is slippery and elusive and just never going to be able to be pinned down, and is more of the sort of poor Justice Stewart, right? He's known for, I know it when I see it, or in this context, I guess I know it when I hear it. And how does that play into these judgment calls you're talking about?
As I said in passing, under the First Amendment, any law that regulates speech has to be clear about what's prohibited and what's allowed. If it's not, it's deemed void on vagueness grounds. Any law that regulates speech cannot regulate substantially more speech than the First Amendment allows to be regulated. And there may be types of speech that we don't like that can't be prohibited because there's no way to do so without being unduly vague and overbroad. I think that's true with regard to hate speech. I've looked at all the hate speech laws from European nations. I looked at a lot of the hate speech codes that were adopted in the United States. They inevitably are so vague. They're things like, you can't have speech that stigmatizes or demeans on a kind of race, sex, religion, sexual orientation. But what does stigmatize or demean mean? And I could give you lots of examples, say, well, is it this or is it this? And that's why every court, without exception, found the hate speech code before it to be unconstitutional.
So I know it when I hear it is actually evidence that it violates the First Amendment.
I don't think I know it when I see it or I know it when I hear it would be an acceptable constitutional standard today.
Yeah.
And I think for the very reason that it comes from an opinion from Justice Potter Stewart in a case called Jacob Ellis versus Ohio, where he said, I can't define obscenity, but I know it when I see it. It has been so mocked, I can't imagine a court would say today it's an appropriate constitutional standard.
I agree. So this is an interesting question, and I wanted to hold it for a bit because it gets back into several of the topics, and it starts with the heckler's veto. And the heckler's veto, is important on social media. It's important at the kind of campus controversies we're talking about. It's important at political events. It's important, for that matter, at city council meetings, right? In some sense. So my understanding of the heckler's veto was that it was based on dangers to safety arising from the heckling crowd's reaction to the speaker. Do you think a heckler's veto with no risk of violence has the same problems under the First Amendment? If there is no imminent risk of violence, does it justify the silence of those who protest hate speech? And is there a right to be heard?
I'm going to break that down into two parts. The first is, what if the reaction of the audience is likely to be so violent as to endanger safety? And there were instances during the civil rights protest era where civil rights protesters engendered opposition from segregationists. And the question is, if the segregationists were likely to engage in violence, would that be a basis for subjecting the speaker? And the Supreme Court ultimately came to saying, and I think it's right, the focus should be controlling on the violent crowd that's acting inappropriately, not the speaker. Now, if it's a situation where the crowd's violence can't be controlled, and the only way to protect safety is to silence the speaker, then the government's justified. But that has to be the last resort. So if we're dealing with situations where there's the possible violent response from the audience, the best thing is control the audience. But now we get to your question, the second part. Imagine we're not dealing with violence. Imagine we're dealing with a situation where it's just an audience shouting down a speaker. I was invited to be on a panel in San Francisco a few years ago to discuss some issues with regard to policing. And there was a group in the audience that didn't want the then District Attorney, George Gascon, to be heard. And as soon as he began speaking, they stood up as a group and shouted so nobody else could be heard. And the moderator politely asked them to sit down. They didn't. They kept shouting. Finally, they canceled the event. I don't believe that they had the right to do that they had the right to keep the rest of the audience from hearing the message. This is the heckler's veto. And as I said, I think then the only speech we'll hear is that which no one cares enough to shout down. And so I think that Hastings Law School, Yale Law School, could have punished the students who shouted down a speaker. And at least in the context of Hastings, I don't think it would have violated the First Amendment to do that. And that's the message I say I transmit to the Berkeley law community, that if there's a situation where the students disrupt a speaker, those students would face discipline and punishment.
One more, I think, sort of campus-focused question.
Sure.
So, you mentioned the obligations that federal laws, things like Title IX, right, place on universities regarding indifference or inequality in the treatment of men and women. And this is a question about intersectionality, I guess, that, what about someone who has two identities that could be the target of hate speech, for example? So where and how are Black and Jewish women, for example, protected when they face racism through hate speech on campus? Are there special, how do we interpret these things as we add up these?
I mentioned this only in passing, and I'm sure many of you are familiar with it. Title IX of the Civil Rights Act says that educational institutions that receive federal funds cannot discriminate on the basis of sex. And this has been interpreted to include that they cannot engage in sexual harassment and that they cannot be deliberately indifferent with regard to sexual harassment. Title VI of the 1964 Civil Rights Act says that recipients of federal funds cannot discriminate on the basis of race. Courts have said this includes a prohibition of racial harassment, and there cannot be deliberate indifference to that. Now, we can talk about what rises to the level of deliberate indifference. In the case that I argued, the campus said, we are going to do nothing and we can do nothing. And there's a whole range of things that the campus could have done without even getting to whether they should have punished the speakers for the expression. And that's what the Fourth Circuit said was deliberate indifference. But of course, there's line drawing in terms of when does it become deliberate indifference? What does a campus have to do to avoid liability? And a lot of that's going to depend on the specific facts and the context.
So I just got another question to bring us back to social media.
Okay.
Why are you more comfortable having someone who owns a social media platform who has an economic incentive to allow more extreme false or hate speech, regulate false or hate speech, than the government itself?
I distrust government power. I think the First Amendment is based on a distrust of government power. I think when it comes to social media platforms, we have the ability to opt out of the social media platforms. I'm not on Facebook, never have been. I'm not on Twitter, never have been. I'm not on Instagram, never have been. I've been able to make that choice. But if I live in society, I don't have a choice to avoid the government regulation. Also, I think here it's important to keep in mind that if the government said to Facebook, Twitter, YouTube, exclude all hate speech, I think that would violate the First Amendment. But if Facebook, YouTube, and Twitter decide that they're going to exclude hate speech, then that doesn't violate the First Amendment. So there's a way in which what we're concerned about is the awful speech that goes on over social media, empowering the social media companies and pressuring them to act may be better, because if the government tries to do the same thing, often it'll be found to violate the First Amendment.
So a follow on, and I'm sure this is one that you have heard from students, right, who one reason they may not be as excited about First Amendment protections is, what do you say when someone says to you, well, the First Amendment is not sacrosanct. It doesn't actually express valuable values. Instead, it simply is a way of empowering people who already have power and influence to weaponize their speech.
Yes, I hear this. I'm trying to say, I'll tell an anecdote and then I'll answer the question directly. In November 2019, Ann Coulter came to speak on the Berkeley campus, and a number of people who were going to hear her speak were assaulted. They were pushed, shoved, water was thrown on them, they were spit at. And some of my students who were going to hear brought me videos the next day of this and showed me. So I wrote a message to the law school community saying, as I did to you tonight, that all ideas and views should be able to be expressed. If we don't like what's said, we should engage in our own speech. I described what I had seen with regard to the videos what occurred to Ann Coulter. And I said it's completely appropriate to protest against Ann Coulter. I loathe Ann Coulter. But to engage in the conduct that occurred here is inconsistent with our values as a community. We need to stand up for the First Amendment. I got a good deal of pushback for doing that. Flyers put on every billboard in the law school that said, you know, Chemerins stands up for Ann Coulter, but doesn't stand up for our students of color. And a message was put on our website that was there for a long time saying that I, quote, and these are the exact words, touted the intellectual acceptability of white supremacist views. I don't think that's what I was doing there and saying that there's the right to speak and the right to not have people assaulted when they go to hear a speaker. A student came to me and said, your message was, quote, like a slap in the face to me. And yet, I still continue to believe what I just said. And what I try to say to students who take the position reflected in the question is that if you look at history, every major advancement in civil rights occurred because of speech. Think of the women's suffrage movement. The 19th Amendment wasn't going to be adopted if it wasn't for the tremendous advocacy that occurred to give women the right to vote. The advances that occurred with regard to civil rights, including the end of segregation, wouldn't have occurred without speech in the lunch counter sit-ins, the March on Selma, and the like. And so I think it's so important for the students to recognize historically the way in which speech has advanced civil rights. I also think it's important for students to realize once they give the government the power to stop the messages they don't like, there's nothing that's going to stop the government from coming after their messages when it's a different government that's in power. That's why I'm so distrustful of the government.
I want to ask a question that kind of steps away from the campus for a moment, right? And brings us back to the larger politics of speech and links it into democracy. And so there's a lot of, we already talked about the January 6th speech of Donald Trump, but is the price of tolerance of extreme false speech on the internet, or we could say more broadly as well, if that results in the creation of political currents that lead to the overthrow of our constitutional system, right? I mean, what's the limit there at some point? Or must we, hold on to speech even if it sinks us?
Let me answer in 2 steps. The first step is, who's going to decide what's true and what's false? And do we want the government to be able to do that? I mean, I think of it in terms of, what if Donald Trump gets elected president in 2024 and he gets to decide what's false speech that can be banned from the internet? It's so easy for government to use that power to say anything that's critical of them is false speech, and they're only going to allow the true speech to be there. The other is in terms of speech that endangers democracy. I mean, we have some history here. We can look at what occurred in the 1920s, 30s, 40s, and 50s when the government tried to punish speech that it saw as endangering democracy. One of those famous cases was Whitney versus California, where a woman was convicted just for going to a socialist convention, and the Supreme Court upheld the conviction. Or Dennis versus the United States from the McCarthy era, where a group of individuals were convicted for teaching works of Marx and Lenin and Engels. There was no showing that their speech posed any harm. The Supreme Court said, well, when the evil is as grave as the overthrow of the government, there doesn't have to be any showing that the speech is likely or imminent to cause that harm. It scares me to give the government that power based on the history that we've seen in this country. But is it possible that speech and false speech will undermine our democracy? No form of government lasts forever. Their democracies are there until they're not. I still would rather put my faith in speech than my faith in government power to censor speech.
Powerful place to end. I'm going to take just one privilege, if I can, because as the non-lawyer in the room, I'm curious about this issue on of the power of social media. So, understanding the difference between social media and government, but when does something that is as powerful and pervasive as social media become like your 9-year-old son's accusation that it carries the power, even if it's not really government, it carries that same kind of power for us?
I can answer descriptively in terms of the current law, and I can raise the question normatively as to what the law should be. Descriptively under current law, it's clear that there are private actors, no matter how powerful, and the Constitution doesn't apply to them. And the Supreme Court has made this very clear. The Supreme Court has said only if it's a task that has been traditionally, exclusively done by the government would we say that the Constitution applies to it. And that's not true of social media companies. There's a Supreme Court case 3 years ago that involved a public access cable channel that was going to exclude speakers. And the Supreme Court said, this is a private entity. It doesn't have to comply with the Constitution. There was a case now 40 years ago that involved a private school that was 99% funded by the government. And it fired a teacher for her speech. And the Supreme Court said, It's a private school. It's not the government. So I think under current law, it's clear Facebook, YouTube, Twitter, Google don't have to comply with the Constitution. And that's true of all powerful companies. Think of how powerful Apple is, or think of how powerful IBM used to be, or think of how powerful General Motors used to be. None of them have to comply with the Constitution. Now, I find the normative question about what should be much more difficult. And I think the question is, should we at some point say that a company is so powerful we want to be governed by the Constitution? But under the conception of the Constitution, that it's meant its rights to limit the government, the law is clear that private companies don't. With rare exceptions, you have to comply with the Constitution.
Thank you so much. Thank you. That indulgence. You've given us all so much to think about, and I think we're all going to continue to stew on these ideas. Our Adult Education Committee is continuing an entire series on this conversation about free speech. I invite you to look on our website to get more information about that. I want to just give a few very quick thank yous to Judge Susan Graber for bringing our guest. To all of our Adult Education Committee, chaired by Susan Milstein, thank you for the work that you've done, to CBI staff, and to our co-sponsored Lewis and Clark Law School. We thank you for your involvement. Thank you. I want to let you know just about two upcoming lectures, both open to the community, and everyone is welcome. On Sunday, October 23rd, Professor Linda Greenhouse, a Pulitzer Prize-winning journalist and legal scholar and frequent contributor to the New York Times and to The Atlantic, will be our guest speaker as our Osran Family Lecture. So I think everybody here will find that to be an important and interesting conversation. She's going to be, the topic of her talk is the year that broke the Supreme Court. So very much continuing on to the themes that we've talked about today. Again, Sunday, October 23rd at 4. And our annual Reverend Dr. Martin Luther King Jr. service will be Friday, January 12th. Activist Leroy Clemens, who's the executive director of the Neshoba Youth Coalition and co-founder and president of the Philadelphia Coalition, will be our guest speaker. Music by our congregational choir, Kol Echad, and members of the Northwest Freedom Singers, featuring Ron Silver, right here. If you have not been our guest for that service, it's really an incredible experience, beautiful music, thoughtful speakers, and something that I think really everyone walks away feeling very lifted. So I hope that you will join us for that and for all the events here at Congregation Beth Israel. Again, thank you so much for being with us today.